Well, good morning and welcome everyone. This is the follow-up question and answer session for plant protection products or pesticides. My name is Lawrence Hodgson. I work in HSE and I'll be chairing this session, and I'm joined on the panel today by the speaker of the previous presentation on pesticides, Rachel Brown, and also joining us from HSE is Julian Cudmore and Russell Wedgbury, and from DEFRA we have Duncan Williams. So the intention here is just to go through some of the questions that were submitted that we didn't get around to on the presentation side, a bit more of a chance to go into a bit more detail. You can continue to submit questions through the question and answer function on this Skype room. And I do encourage you to keep submitting questions, because if we can't answer them right now today, we will be taking them away and we will be filling in any gaps that we find on our website or through e-bulletins or whatnot. We won't be able to directly respond to questioners. So if you have a really urgent question, I encourage you to use the help desk or the helpline if we can't answer it in the next sort of half an hour. Having said that, then we might as well kick off and dive right in. I hope the panel's sitting comfortable. I've got a few questions to begin on MRLs. I think this might be for Julian and Russell here, but I'll start. I'll start now. So, in circumstances where an EU MRL comes into force, which is higher than the current GB MRL, will there be put in place a fast track mechanism that will permit the GB MRL to be increased to match the increased EU MRL, either by submission of data or by some other mechanism? Did that make sense?
Yeah, so I'll answer that, and Russell can jump in as well if he has any further thoughts that he wants to add. So essentially, we don't have a fast track system for MRL. So if you want to increase the GB MRL, that will require a specific application to HSE with all the data that supports that assessment, and we will have to evaluate it, and it will be done in line with our standard data submission deadlines, which are a standard 12 months for the assessment plus 6 months given to provide any additional information. If the EU has already done assessment, just as with if any other jurisdiction has done an assessment, we can take that into account in our decision-making process. And clearly, if the application is quite straightforward, or you have discussions with HSE about how important a particular MRL is, then we can always have discussions about prioritizing assessments, but there isn't any specific fast track application to get the MRL done just because the EU has implemented an MRL.
Okay, well, I'm going to stay on the same topic. So I've got a few more MRL related questions for now. So sort of following up in the same theme, if we are submitting this month confirmatory data following an Article 12 review, should we submit that confirmatory data to UK separately to ensure MRL is the same in both territories?
The simple answer to that is yes. So the data gaps will remain valid for GB MRL, so those data gaps remain outstanding, so we would need to have an assessment specifically to HSE. Yeah.
Okay, thank you. Well, assuming that EU MRL requirements are satisfied, are there any restrictions on the export of fresh produce to EU imposed by HSE?
I'll answer that one. No, the answer is no. There's no specific legislation which applies to export. All MRL regimes that we've operated via Europe or separately for GB are to do with produce which is being brought in to your territory. So there's no specific controls with regard to MRLs for exported goods, although of course you would have to comply with the rules that apply in the country of export.
Thanks, Russell. I've got sort of one last MRL one for now, and then we'll move on to other questions as they come in. As MRLs have been read across from EU legislation, this is 396/2005, how does this apply to Annex 4 MRL exempt cases? is there a GB equivalent to MRL exempt list that will be added to independently from the EU Annex 4 396/2005? So will there be a GB equivalent to the exemption list for MRLs as they are in the EU system?
Should I take that one? Yes, there is going to be a GB list. In fact, it exists already. It's if you go onto the register on the website, the first page shows a link to what we call now Part 4. It's no longer an annex, it's Part 4. And as it stands, it will basically mirror what is in the Annex 4 listing that you have under the EU regime. Obviously, as time goes on, that may all diverge from the EU system, but in the same way as we assess and set listings of active substances on Annex 4 previously, we will do that for the GB regime. We will consider and add or subtract active substances from that list with regard to active substances which are exempt from MRLs.
Thanks, Russell. I've got an IT related question then. So if we have an IT application and progress in the EU and that commodity will be imported into UK, either directly from the exporting country or via EU, should we submit the application now to CRD to ensure we have the IT in both UK and EU going forward?
Yeah, I'll answer that. So the answer to that is yes. So if you want the produce to come into the GB and therefore you want the MRL to be raised, then that import tolerance application will also need to be submitted to HSE so we can undertake the full assessment.
Brilliant, thank you, Julian. I've got a question on authorisations here. So will CRD consider updating their authorisation notices to include details of the authorisation type, such as Article 33, Article 34, Article 43? In particular, it is currently rather difficult to tell which product is the first to be re-registered following active substance renewal. This is important as active substance data protection starts from the date of the first product re-registration in the UK. Who on the panel would like to sort of take that up? I can read it out again.
Oh, I can take that one. Yeah, that might be useful. It's something we can consider to identify some types of authorization, but there's some aspects that might be considered confidential, revealing market strategy, that kind of thing. So we'd have to consider it, but for transparency reasons, it might be appropriate in some cases. Something for us to take away, I think.
Thanks, Rachel. I think this one is on technical equivalence. So if an applicant wishes to add a new source of an active substance for which technical equivalence was assessed by the EU member state to a UK approved product, does the applicant simply submit the technical equivalence dossier, and that's the report and supporting data, with the additional source request application? If so, is an independent GB assessment conducted on the technical equivalence?
So I think we probably covered this in the main presentation.
Apologies.
Yeah, no, it's fine. A GB technical equivalence assessment will be required, yes. We'll need to have a GB assessment because we won't have access to the full confidential information of previously assessed sources.
Got a question on the sort of the guidance available on the website. It might be one to sort of reflect on again, but I can see on the HSE website, pesticide register search, we now have different search options in the third drop-down list, the extent of authorization. Is there any more guidance available on this? So is there a guidance on navigating the website and using the different search functions?
I thought there was going to be one, so it might be something that's coming as the next part of the work that we're doing on the website. But essentially, it's there to enable us to be able to report accurately products that could only be used in GB or in Northern Ireland, where divergence has occurred. That's the purpose of that aspect on there, to be able to give that clarity. I'll check the footnotes, but I think we intended to put some footnotes into what that search was intended for.
Thanks. I've got a question on the active substance database and sort of seeing the history throughout it. So the EU active substance database contains a very useful history of the authorization under each substance. At the moment, the UK database contains no such information. So a substance can apparently disappear suddenly with no explanation. And they give an example here of Oxymil, I might be butchering that, in December 2020. Can HSE consider an update to its database at some time so we can see the history of authorizations? I don't know if that's one to reflect on.
Yeah, that's one to reflect on, but I can see why that would be useful. Yeah, we can certainly look at that.
Going back to technical equivalence, what reference specification will GB use for technical equivalence?
For that, we will use the specification that we have the full details of prior to the end of the transition period. So it's the tech spec that we sort of adopted as a GB tech spec at that time. If we don't have full details of any tech specs, then we will require full application and the information to be provided to support that.
So I've got a question here around product applications and how they relate to sort of GB and Northern Ireland. So for a product application, HSE can access the application for GB and NI, but in the case of NI, it has to be an application in the frame of a central zone application. Is it possible to submit only one DRR for GB and NI with a core dossier and specific UK addenda? Is it necessary to submit the central zonal application in an EU ZRMS, which is not NI? So hopefully that makes sense. But it's sort of
Yes, it does.
Yeah, what's the process? Northern Ireland and GB.
So where there's no divergence, as we said in the presentation, we can accept the same information for a common GB and NI application. Where there's no divergence, it's the same information that's required for both locations, and that will be UK specifics as well. So any UK specific addenda that would be required. But you've got to remember that NI just can't act as the lead for any application for any member state, because we don't have member state status, although they are bound by the EU rules. NI isn't member state status, so they couldn't act as a lead member state.
Thanks, Rachel. There's a question then here on reviewing active substances and the sort of notice given to stakeholders. So when HSE decide to perform a review of an active substance ahead of the GB expiry date, and they got an example of Mancozeb, what sort of advance notification and review timelines can we expect? Applicants need to be able to prepare to address any issues that may have arisen properly.
We haven't confirmed those details. I would expect that it would be as much notification as possible, but I would expect that the approval holder of any active substance where there were concerns would be aware of those concerns anyway. There could be triggers such as EFSA concerns, critical areas of concerns, or non-approval decisions in other member states. They could be possible triggers for review, or any sources of adverse data really that we would look at, and we would give as much notification as we possibly could.
I've got a follow-up question on that substance I just mentioned there, and you might have just answered it there that we're looking into this, but on Mancozeb, when is the decision on a date likely to be made? I'm not asking for the expiry dates themselves, but rather how long will it take to HSE to make a decision?
I don't think I can confirm that at this time.
No, I thought as much. I'll just throw it out there. Okay, so there's another question on sort of the different processes for GB and NI here. So in my understanding, if my understanding is correct, that for commodity substance area, an application for renewal will need to be made to both the HSE for GB and NI separately if we wanted it to be available for both GB and NI? Or is it the case that to use it in NI, an application would have to be made to the EU? And if so, would that be via the HSE or not? So what's the process for getting an application for renewal across the UK in both GB and NI? Is it to apply to HSE separately, twice, via the EU? Would anyone be able to comment on that?
I have to say, commodity substances are not an area of my expertise, and I wouldn't really want to give the wrong answer here. So is it okay if I take this one away and get back to the Inquirer Direct?
Yeah. And just to remind everyone, please keep submitting your questions. The ones that we can't answer today, we will be taking away and filling any gaps on our guidance, our website, our bulletins.
Unless Duncan, I don't know if you've got any commodity substance. No, I know that there's special issues regarding commodity substances that I wouldn't want to give the wrong information, so I prefer to take that one away.
Thanks, Rachel. Maybe I do have a question here for Duncan then, and it's on transparency regulations. Will the EU transparency regulations as part of the general food law be implemented in GB?
Right, okay, so this relates to the way that EU law is retained in national law as we leave the EU. So the way that the EU Withdrawal Act works is that if legislation is in force at the end of the transition period, then it does get retained. Now, these particular regulations, I think it's EU Regulation 2019-1381, do not come into force until early 2021. So they're not in force at the end of the transition period, and they're not automatically retained by the Withdrawal Act, so they won't come into force in GB.
Thank you, Duncan. I've got a question here on approvals, and it's, is there any update on off-label or EAMU approvals? Does that make sense to you?
Yeah, I can take that one. Yeah. So EU authorisations, it remains unchanged. All existing EMUs that existed prior to the end of the transition period have been carried forward. They will continue to be applied for in the same way on the back of existing products. So there's no change to the EU conditions, unless there was anything specific behind that question. There's no change.
I'm not sure of the intentions, but it just seems like a general question. So yeah. I think that answered it. Thank you, Rachel. Another question on renewals then. We understand that for renewal of AIs, in the short term, only an administrative application will be needed and the full dossier will be required later. However, we have to plan ahead. Could you provide more indication on when the full dossier will be required for submission in GB?
That hasn't been finalised yet as part of the review programme. However, I don't think it'll be that different to existing conditions.
Okay. I'm going to turn to some of the questions we've had come in during this session on the Skype Q&A, and just to remind people, we have about sort of 10 minutes left before the next session on CLP is going to start. So I'll just sort of try and work through some of these other questions we've had coming through. So I've got one on import tolerances and MRLs here. Will there be any specific provisions for assessing GB import tolerances, or will it just be like a standard MRL submission? So I don't know if Julian or Russell, you might be best placed to answer to that.
Yeah, I can take that. So the process of assessing an import tolerance will be exactly the same as it was when we were an EU member state. So it'll just be a standard MRL assessment. Just like we did before, though, we need proof of authorization in the exporting country. So it's clear that we're setting an MRL for something that's actually authorized in that third country, and the standard processing times are exactly the same. So that's 12 months plus 6 months to provide any additional information.
Thanks, Julian, sorry. Got a follow-up question on the EU food law. So this might be possibly for you, Duncan, if you can answer to it. There were indications from EFSA that depending on the nature of a trade deal, it may be required that CRO in third countries may need to co-notify studies. Will UK labs be required to co-notify? I don't know if that's something you'd be able to speak to.
I'm afraid it's not something I've got any expertise in, so I think probably that's one to take away and investigate with probably food policy colleagues. Okay,
no, thank you. I've got a technical question on the I think for the how active substance dossiers are submitted. So in the EU, they use the Euclid format. Will CRD accept the same format? So will CRD be using Euclid for active substance dossiers?
So we made a commitment that we would accept common formats wherever possible. We haven't previously accepted our Euclid, but we are looking at the capacity of our IT systems and capabilities and making sure that we could move to accept in a common format just to minimise that burden. So hopefully we'll be able to accept a common method for submission.
Thank you, Rachel. I'm just getting to the sort of picking another question. I've got one on pre-notification. Is a pre-notification of the submission still necessary ahead of the application for authorization of the PPP? Will there be a limitation in terms of applications HSE can handle per year, which would extend the timelines for an authorization of the PPP? Is that something anyone has sort of expertise and they could maybe speak to? Or is that something we're still yet to determine because we're in the new systems? We're not yet sure of the workloads that will be coming through.
So obviously in terms of communication between applicants and ourselves, as sharing of as much information as possible about whether you intend to support active substances or not is always helpful. So communication, we always welcome that communication in terms of understanding demands. Obviously we are moving to a situation where HSE will be carrying out reviews that were carried out across Europe, and we're looking at our resources and our capacity, and we'll be expanding and taking on more staff to be able to meet the needs of the regimes.
Thanks, Rachel. There's one here on renewals of active substances again. So if the application for renewal of an active substance would not be submitted, does it affect the expiry date of the active substance? So is there any impact on the expiry date if there's not an application for renewal submitted?
So initially, I'd say no. The existing active expiry date would stand. However, if there were serious concerns about that active, as we've been saying in a number of presentations, you know, we may want to look at that more closely and see if it's appropriate to allow it to continue to that expiry date. But in essence, it wouldn't affect it in the first instance.
Sort of a similar question here on active substances, again on the submissions, where an active substance, the confirmatory data submissions have already been made to the EU, where during the time when the UK was a member and part of the process, and should have received that data. Will we also need to resubmit this information to HSE, a bit like a GB renewal process?
Yeah, because we probably won't have access to that if it's been submitted to other member states particularly. We might not hold it as GB. So we will require resubmission of information that's been previously submitted in those cases.
We've got just a few more minutes left, so I'll just a couple more questions maybe, and then we might bring the session to a close. So just a few more to challenge our panel with here. I've got another one on the review program. I'm not sure if maybe we touched on the answer in the preceding questions, but in the GB review program for active substances, no dates are given at which the dossier shall be submitted. Does GB follow the standard timeline of 6 months after the application? Is that something that we haven't answered yet?
No, we haven't answered that yet. In terms of we haven't published it or we haven't taken a decision on that. It's likely that timelines are going to be similar, and hopefully we should have something out on that soon, but it hasn't been confirmed. So you've not missed it as such, but we will get something out on that.
Thanks. Just last couple of questions then. Just bear with me 1 second. I'm just trying to pick up stuff we might not have touched on. So I've got another one on submitting the renewal of an active substance. So the application for renewal of active substance has to be submitted to HSE 3 years before the expiry of the active substance. But what about the dossier submission? So companies need to know by when the dossiers have to be generated and submitted. This is especially true for active substance renewals, which are not finalised until the end of the transition period. And they're saying in a lot of cases, dossiers have been submitted in the EU 6 years ago or so the applicants will need to prepare an updated dossier with new data requirements and new guidance documents for submission in GB. So more of a broad question there about just sort of when exactly along the process with dossiers need to be submitted, and do they need to be updated if they're quite outdated? Well, if they're a few years old by the time they're being resubmitted in GB.
Again, I think that's something that we'll get some detailed guidance on out on shortly, in terms of what needs to be submitted and by when, what those dates will be. I've just seen one slightly differently. It came into one of the other inboxes by mistake, I think, or a more general inbox rather than the PPP inbox. There's a different kind of question about data matching tables. Will we have to submit data matching tables to the UK? And yes, the answer is yes, data matching tables still will be required for GB to be submitted with Article 43 applications once the Act has been approved in GB. And another question was to do with no data applications based on comparability of composition of a submitted composition versus reference product. Yes, we will still accept no data applications. Those were sort of different questions that had come into the general question box rather than the PPP one, but they were for us. They just got forwarded through.
Thanks, Rachel. And I think just before I wrap, there's another thing here mentioned about Mancozeb, and I think we did answer this earlier, but just to sort of confirm if someone may have missed that we're still yet to take a decision about the final dates of when a decision will be made. So that will be communicated yes, as in due. It's when it's
as soon as possible, as soon as we can.
Yes. So I think just sort of rounding up then, really useful session. So I want to say thanks to all the panel, to Russell, to Rachel, to Julian, and to Duncan. I think we went through quite a lot of questions there. So well done on answering what was presented to you today. And as I say, the questions we weren't able to answer at the moment, we are taking away and we'll be working on. And please continue to submit questions if you have them. And for anything urgent and burning that we weren't able to get through in this session or during the presentation, please use the help desk or the helpline for those. Otherwise, just to note, at sort of 12:20 will be this link will be opening back up for a Q&A on CLP. So having said all that, thank you to the panel, and I'll be back here in a couple of minutes for CLP. Thanks,
Lawrence. Thanks, everybody.
Bye.
Bye-bye.